Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is November 29th, 2018. This is our bi-weekly community conference call, which we hold for your immigration-related questions. I'm going to go over the questions I have marked for today, the ones that are frequently asked questions first. If you folks have any follow-up questions, we'll take those. And then I will continue to answer the other questions that are non-frequently asked questions. But I don't think we're going to have time for new questions. We'll deal with all the questions that have been posted and their follow-ups. First frequently asked question is, what is the effect of an L1A denial on an approved EB1C green card? So you can have a situation where you have your green card approved under the EB1C category of international managers and executives, not the green card. I should have said it is not EB1C green card. It is actually I-140. I miswrote that. So you have an I-140 approved on an EB1C, but your L1A gets denied. Is there an effect on this? The question says, I have my EB1C I-140 approved, dates are not current, but my L1A change of status is rejected. So I'm not sure exactly what happened. Is it the L1A that was denied, or is just the change of status? Because if it is the L1A denied, that presents a different set of issues than if it is just the change of status. If you are available in this conference, press *5 on your phone, sir or ma'am. Press *5 if you're on the conference. Okay, I'll try to cover both eventualities in the time that we have. So if your L1A is denied, not just the change of status, then we have to look at the reason for denial. Typically, an L1A is denied if they are not convinced, if the government feels that you don't rise to the level of an executive or managerial employee, for whatever reason, whether it's on the foreign country side or US side, if you don't rise to that level, government can deny your L1A. And if they are denying the L1A on that basis, and your EB1C I-140 was approved also with the same or similar job description, then obviously there is a potential impact, because the criteria used for determining your eligibility for L1A and EB1C are the same as far as qualifying as a manager is concerned. So indirectly, because you are using the same job description, you could have a problem with the L1A denial. If it is just a change of status denial, which can happen because you filed your application 2 days too late, any number of things can happen, then the green card I-140 remains unaffected. But then you have to worry about the unlawful presence problem. If you have been unlawfully present for 180 days, you cannot come back for 3 years except with a 212D3 waiver. And that's always a possibility in these sorts of cases. That's really the only option you have. The other options are so remote as to be inapplicable to most people. So that's the way it works. Can you stay in the United States? And the answer is, of course not. Right now you have an H-1B which expires on 20th January. But if your H-1B is still valid and you are maintaining H-1 status, you could refile the L1. What is the problem? And you also have premium processing available, so you could file L1 premium processing. So I'm not sure exactly. This situation has certain gaps which I can't fill in. If you are on the phone about the L1A denial, the first question, press *5. Okay, anybody has any follow-up questions on this before I move on? All right, let's go to the next frequently asked question. And this is about, how does the priority date transfer work when you have an approved I-140 and you are filing a subsequent I-140, what special dance do you have to dance to get the priority date transferred? The answer is not any, really. The law requires the government to automatically assign you the earliest priority date to which you are entitled. Up until a few months ago at least, they were running routine and regular checks to see which was the priority date to which you were eligible or entitled on a monthly basis. So they would run, they call it a check, basically. For those of you who you are techies, you can think of as an SQL query where they see what your earliest priority date eligibility is, and they automatically give it to you. Because there is nothing special required to be done, you can always request the earlier priority date if the government has not done it for you, with just a letter, or sometimes even with opening a case request online with the government customer support. So there's nothing really special that they have to do. You said, I have an EB2 I-140 priority date of March 2017. EB1 I-140 is August 2018. Attorneys have filed an amendment of priority date. Why? If your priority date becomes current at any point of time, you can just go ahead and file your I485 with copies of both I-140 approvals attached. So I'm not really sure what was the need for amendment, but the transfer of priority date, takeaway points are, does not require any special shenanigans. You're supposed to be entitled to it automatically, and usually a letter or a service request made over the telephone should be enough. And if nothing else, if the dates become current, file with both I-140 copies attached. Your 485 can be filed. *5 if you have any follow-up questions on this. Anyone? Press *5. I will not be doing new questions today, just follow-ups on posted questions, please. Okay, I have a call scheduled at 1:30, so I'll have to call off at exactly 1:30. Let's go on to the next frequently asked question from Moshe. It's, what is the maximum period of stay allowed for tourist visa entrants? So somebody's parents come to USA every year and they stay here for 6 months, let's say once or twice or 3 years in a row. Can government create a problem? And obviously they did in this case. The idea is, when you come to the United States, you're coming for a visit. So if you are coming for a visit that's overly long, government can take the position that it looks like you are living in the United States and visiting your home country periodically. So it cannot be, there's no rule of thumb, there's no mathematical rule that I can give you or anyone can give you that will tell you that a certain number of months every year is safe. I would say that 2-3 months maybe every year is non-objectionable. But in this case, what happened was, when they came the last time, could CBP have placed an adverse mark in their system? I'm not sure that's a given. I think that they can. They usually put it on the passport. I don't think they have a system-based alert for something like this, although they might, and they should tell you when they do that. Typically, that's their process. I'm not aware of any standard operating procedure like this. So what is the preventative? To stay less than 6 months each time you come, or if you have stayed 6 months in a year, then don't come back the following year. Wait another 12 months before you come back in. That would be prudent. *5 if you have a follow-up question on this. *5. If you press *5 on your phone, I can see it. Okay. Let's go on to the next frequently asked question. So this is another interesting situation. How do I continue my employment-based green card while moving outside the USA? Let me take a second to explain the theoretical underpinnings and the most common logistical and practical problems that we see. I've dealt with this issue several times in the past, but I like to update my answers from time to time. You can go to our frequently asked questions on immigration.com and go through many times that I've answered this question. The basic premise remains the same. The green card offer from the employer who started your green card continues to be alive and well. Your intention to rejoin the employer continues to be alive and well. And by a mutual consent arrangement, you have decided to move to another country or to your home country, even though you're not working with this employer any longer, you're not maintaining your H-1B or L-1B, that's fine. You can do your green card through consular processing, or anytime you want, you can convert to H-1B again or take H-1B status and start working in the United States. And when the dates become current, you can file 485. But if you're outside USA, make sure that USCIS has been informed. So when the dates become current, they will transfer your file to appropriate consulate for visa processing, green card under consular processing. So if the priority date becomes current during my stay in Canada, what are my options? Two options. One is to go through the consular processing in Canada, or second is to get an H-1B status approved. Since you're not subject to the quota for 6 years after approval, you can come back on H-1B and file adjustment of status. If priority dates don't become current and I try to enter USA on an H-1B, so the problem with an H-1B that's too old, that's a stale H-1B, it certainly becomes a red flag issue for the CBP to ensure that you still have the job. And how could the employer do without you if they had an active project? So it can certainly create certain questionable situations. I don't know if they will necessarily question you, but it's definitely common for them to be concerned about this sort of a situation. Would a letter from the employer be enough? That depends. If the job is in-house, for example, the company is a product development company and they intend to hire you in-house, then a letter from the company should be good enough. Pay stubs are not necessary, but if you are working for this employer from outside the United States, you can certainly present pay stubs to prove that you were working for this employer. That is not directly relevant, but it does show an ongoing relationship whereunder it's reasonable to assume that they still have a job for you when you come in. Then another situation you're presenting is, if H-1B has expired, can I use my approved I-140 to file a new H-1B extension? Definitely. Definitely. You don't have to re-enter the lottery for 6 years after the last H-1B approval. Okay. *5, if you have a follow-up question on this, *5. No new questions. Please press *5 on your phone if you have a follow-up question. Okay, let's see. So we have a question from New York. New York, go ahead, please. New York.
Yes. So Ajib, for the first question is right now, when I'm entering that at the port of entry, is there my main concern is at the port of entry, what kind of questions they will be asking? Is there anything I can do from out of state while entering back to the US? I can keep the documentation with me.
Well, hang on one second. You said when I'm entering. Well, my question would be, under what circumstances are you entering? Are you coming back to resume employment on existing H-1B? Are you coming back in on a new H-1B? What are the circumstances?
The resume one.
You can, if it is an in-house employment. What documents? I would say a letter from the employer explaining the circumstances. Have your attorneys make sure that they explain for or provide for the situation that you're outside the USA. So if I were them, I would probably prepare some explanation why you were outside, explain to them what the need to be outside was, and I think that should be sufficient.
Okay. Okay, thank you.
Oh, you're welcome. Good luck, sir. Okay, so I have another question. Let's see. And this one is from Maryland. Maryland, go ahead, please. Maryland. Oh, hang on. I think I forgot to. Let me just make sure what happened here. Oh, you hung up. All right. You put your hand down. All right. Let's go on to the next frequently asked question. And this is also common. This question. Oh, you're back again. Yeah, Maryland, go ahead, please. Maryland.
Actually, my I-140 is approved, but my employer withdrawn.
Okay, ma'am, stop.
Right now
Stop right
I'm-
there, ma'am. Stop right there. I'm not doing any new questions today. I don't have time. But if your question is a follow up on anything that comes up, feel free to raise your hand again. Okay. Sorry. Okay. So folks, I don't have time for new questions, but whatever has been posted, there are I think 19 questions posted, and any follow ups on those, I'll be happy to do. Okay. So next frequently asked question is starting business on a 485 EAD. The answer, simple answer, sure you can. You can work for yourself. You can do multiple jobs as long as you have an EAD. But remember, using the EAD will put you out of your H1B or L1, whatever status you are in, or H4 or L2. Then you'll be on EAD pending 485 adjustment of status, authorized period of stay. You can reactivate your H1 or L1 by going outside, getting a visa stamping, or if you already have a visa stamping, coming back on that, and then you are back again on H1 or L1. The moment you start your own business or start doing something on the side, in addition to your main job, you are on EAD then. Can I still work on a 1099? Sure. The only problem is it shouldn't be for the employing company. So if your company, let's say IBM, filed for your green card, you shouldn't go to a 1099 with IBM. You should stay on their W-2 because green card is not based upon independent contractor status. It's based upon a W-2 job. But if on the other hand, you're getting a short-term contract, let's say a 6-month or even a year-long contract with Sun Microsystems, you can certainly go ahead and do that on your EAD. Or if you want to start a business on the side, whether in your own field or some other field, it doesn't matter. That's okay too, as long as you are not losing focus of your main job. That's the job that got you your green card. Okay. *5, if you have a follow-up question on this, press *5. No new questions, please. Any follow-up question on this? Okay. So here is another question that people were very concerned about NTAs, etc., notices to appear. Well, first of all, government has said that they are not going to issue NTAs in employment-based cases. So you don't have to worry about that. And secondly, once you have filed for an H-1B extension or transfer, as long as your case is pending, you are not out of status. You are in authorized period of stay. Okay, so there's no doubt about that. That's well-settled law. So let's see what your questions are, Sri. If my extension is applied in premium before I94 expiration, but it stays pending till after the expiration, will I be out of status? I have said no, and there's no NTA. Even if it gets denied, you can leave the United States within a short period. After the denial, you won't get an NTA. Is it better to leave the country on the last day of I94 expiration? No, sir. You don't have to do that. There's no question of unlawful presence or being out of status when a timely filed extension, amendment, or transfer request is pending. And if you choose to leave the USA for whatever reasons, you can always get a visa and come back. Traveling outside USA does not abandon your H-1 request. So no issues. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay. Let's take the next frequently asked question. Now this is another situation that's coming up quite frequently. So I have an approved EB2, but I want to apply under EB3 category. Can I? And the answer is, last time we looked into this, and we have looked into both the law as well as the procedure. This is mostly a question of procedure and policy. USCIS has been indicating if you have only one I-140 approved under EB2, but you want to file under EB3, you have to file another I-140 using the same copy of the same labor certification perm application and get an EB3 approval first. Can you do it concurrently if the dates are current? I don't think there's a clear answer to that. I'm not sure what our office is doing, but my preference would be to get the I-140 approved first. But if the priority dates are moving fast up and down, I would take a chance. Of course, I would want to double check with the USCIS, see what they say before I do a concurrent filing along with an EB3 I-140. I hope that's clear. *5 if you have a follow-up question. *5. Oh, I forgot to add one more thing. What if you have an EB3 and EB2 approval? Can you still file an EB3 based 485 with an EB2 approval in hand? And the answer is that depends. If you're willing to take the lower job and the employer who processed the EB3 I-140 still has that job for you, you can certainly file. Does it affect your EB2? Normally, no. Why should it? These are two different cases. *5, once again, if you have a follow-up question. Okay. Let's go to the next one. This is a very, very common scenario, and it is an egregious and unjust scenario where your I94 expired because you didn't look at it. This happens a lot in the case of family members. So typically a wife will leave the extension to the husband, and the employers or the lawyers did not check on whether the family needs extensions. They just do the H1 extension. Next thing is the H4 family has accrued unlawful presence, and they could be barred for 3 or 10 years. So let's see exactly what's going on. I'm an H4 dependent visa holder. I94 expired 9 months ago. That means 3-year bar if you leave USA. This was due to old passport expiration. My visa is still valid. Can you provide the best solution? Well, you can certainly try nunc-pro-tunc, which means retroactive reinstatement, by filing for an H4 with the government. The problem is there is no premium processing for H4 filed by itself. So it could take them more than 6 months to decide the case. Next thing is you are subject to the 10-year bar. Under the circumstances, unless there is something here that I am not seeing, of course I would want you to consult with your own lawyers, get into the details, nitty-gritty. I can only give you broad suggestions. I would certainly look into 212D3 waiver. 212, D as in doctor, Arabic numeral 3. What is the 212D3 waiver? 212D3 waiver is given to those people where they have become subject to unlawful presence 3-year or 10-year bar, and there's no reason, policy reason, for the government to withhold their entry on a non-immigrant visa. So let's say you go to India, or I'm not sure which country. Yeah, you're from India. So if you go to India, you apply for your H4 in the paperwork that you submit to the government, the DS-160. You say, yes, I've been out of status and I have been unlawfully present for over 180 days, but less than 365. They could say, okay, we can't give you a visa without a waiver, and they'll give you the paperwork to make the application for the waiver for 212D3. They are then supposed to forward it to CBP, which then does the waiver and sends it back. Normally, I think the waivers are given for up to 5 years, but usually they make it coextensive with your current H4. And if you need to apply for an extension within USA, no problem, you don't need a waiver. But if you are outside USA and you need to come back and the old waiver has expired, you can always get a new waiver. There's no limit to how many times you can get a 212D3 waiver. The good thing is, once 3 years pass, then the waiver is no longer applicable. Remember, the Unlawful presence bar does not require you to be outside USA for 3 years, merely the passage of time of 3 years. You cannot get a green card for 3 years. You cannot get, you can get any kind of non-immigrant visa, even H1 or L1. You just can't get a green card. But you don't have to be physically outside the US, okay? Yeah, I don't see you getting nunc-pro-tunc approval without running the risk of the 10-year bar. That's my only problem. But please, this is a serious issue. You don't want to take my word given in a 3-minute conversation. You definitely want to talk to your own lawyers, or if you want us to review your case, we can set up a consultation for you. *5 if you have a follow-up question. *5. It looks like I'm losing my voice. *5 if you have a follow-up question. Okay. Let's go on to the next. Is there another frequently asked question? No. We are done with the frequently asked questions. Let's go to the regular questions now. So this is a question about travel during H-4 EAD processing. I'm currently on H-4, good till 2020. I want to travel, filed for H-4 EAD. Is it okay to travel? The answer is yes. USCIS has said when you are on H-4, valid H-4, and you filed for an EAD, you can travel. But they did say that it can delay your application. I don't see why, but they discourage it. I think the reason they discouraged it is what if you're gone and there's an RFE or something on the H-4 EAD. Personally, I don't see any problem with travel. *5 if you have a follow-up question. Now, this answer would not hold true if you had applied for a change of status. So if you were on H4, H1 and you applied for H4 and H-4 EAD together, then if you leave, you've lost everything. You'll have to go get H-4 visa stamping done, come back and apply for EAD again. All right, let's go on to the next question. So this is also a situation that comes up. If you file an I485 and an EB2 concurrently, I-140 concurrently, and the I-140 gets denied, what is the net effect of that overall? You are still maintaining your H-1B status. Is the obtained EAD not useful anymore? The answer is no. Because it used to be, and I could be wrong about this, have it double checked. There are so many little nuances in immigration law. As I recall, USCIS went back and changed some of their regulations in January 2017. Earlier, if you had an I-140 denial, until they actually went and revoked your EAD, you could still continue using it. I think they've changed that law. Now, if the I-140 is denied, you should stop using your EAD. In any case, they will come after it. They will deny it, even if they have not done so already. Can you refile the 485 after the EB3 I-140 is approved? The answer is yes, if the dates are current. Will you get another EAD card? Yes, you will. You will. When you file another 485 with the I-140, which is either approved or not yet denied, you will get an EAD with that. *5 if you have a follow-up question. *5. Okay. So let's go on to the next non-frequently asked questions. I did all right. I did zip through these questions fairly quickly. And if there's time remaining, which might be, I'll be happy to answer any questions you folks have. So let's see. This one we did already. This is the frequently asked questions. Okay, yeah, this is another one that comes up very, very frequently. So I have a 3 years Indian bachelor's degree. I have 5 years of experience. Can I qualify for EB2? No. The rules for H-1B and green card for experience in lieu of degree are different. For H-1B, you have a 3-year degree and 3 years experience, you are equivalent to a bachelor's. But that's not true for green card. Green card allows no such aggregation. There is no substitution of experience for a number of years of college to arrive to an EB2. You will never qualify for an EB2 with a 3-year degree unless you had a combo like a 3-year computer science degree with a 3-year Master of Computer Applications. So that makes it 3 plus 3, 6 years of education, college level education. You could do an EB2. Or here's what I would do, and typically this is what I do for our own clients. I start an EB3 green card, and while that is going on, I would recommend that you do a master's degree in the United States through an accredited program, whether online or in college. Because on H-1B you can study, L1 you can study, part-time or full-time. And when the master's degree is done, if there is a job that requires a master's or BS plus 5 type experience, BS plus 5 or master's degree experience, then you can go ahead and refile another green card for the EB2 position and transfer the priority date from the earlier EB3 approved case. And that is really a very good way to do it. So let me give you an example. Let's say that in 2018, I gave you the suggestion, start a master's degree. We start your green card. It gets processed under EB3 in, let's say, 2020. In 2020, you also finished your master's degree, or 2021, you finished your master's degree. We can file another green card from scratch, and that's going to be an EB2 because you have a master's degree, and as long as the second job that's being offered requires a master's degree, you could go under EB2, and the priority date of the 2018 case will get automatically transferred to you. So that way, even though you started your EB2 green card in 2020 or 2021, it's deemed to have been filed in 2018 because you have an earlier approved EB3 green card, I-140. So go ahead and go for that strategy. That might be a better way to do it. Star 5 if you have a follow-up question. Star 5. I hope I'm not zipping through it too quickly because I'm so used to these concepts. Maybe sometimes feel free to raise your hand if something is not clear, guys. Okay. So Abhijit says, I'm an India-born Canadian permanent resident. I'm living in Vancouver. I worked in Seattle 2015 to 2017. Current employer had also filed I-140. I've got a priority date of March 2018. We're having a baby. Congratulations. Baby would be born in Vancouver. She'll be a Canadian citizen. Now, can the baby get a green card based upon the I-140? No. Whatever happens to you gets inherited by the child, but the child independently cannot take advantage of your I-140 in any manner. Star 5 if you have a follow-up question. Star 5. Okay. Manasa says, I'm currently on H-4 planning to apply for EAD after the spouse's I-140 approval. I was on H-1 previously till September 2017. My own I-140 was approved. My employer withdrew the I-140 in March 2018. Now, the good news is, because your I-140 was approved and stayed approved for more than 180 days. So September 2017 to about April 2018, it's 180 days. Oh, no, sorry. I take it back. It was withdrawn before 180 days in March. So just short of 180 days. Can I apply for my H-1 in premium processing? Well, first of all, if you have time left on your H-1 from the initial 6 years, you can certainly file for an H-1. You are not subject to the quota because you had an H-1 till 2017. So quota is not an issue. Can you start working right after you file the H-1B? No. That option is only available for those people who are maintaining their H-1B status. So because you have a gap in your status, you are going to be on H-4, you will not be able to join based upon the filing. You have to wait for the approval. Star 5 if you have a follow-up question. Star 5. Okay. This one is, let's see, from Baltimore? Yes, from Baltimore. All right. Yes, Baltimore, go ahead, please.
Hello, sir. Actually, my 140 got approved in 2013. So my question is, can I apply H1 in premium processing? I mean, am I
No,
eligible to apply
no,
in premium?
no. Premium processing has nothing to do with when your I-140 was approved. Right now, premium processing is only available for quota exempt positions and for extensions without change.
Oh, okay.
But in February, they may reinstate those, so you'll be okay. All right.
Okay. Mm-hmm.
Good luck, ma'am.
Okay. Thank you.
You're welcome.
Thank you.
Okay, so I have an approved, this is from Achala. I have an approved I-140 from employer A. I transferred my H1 to employer B, but I got only 1 year extension. Can I now get a 3-year extension next time? Yes. Once your I-140 is approved, you can get 3-year extensions if your dates are not current. But oftentimes, government is restricting H1B to the duration of the project. So if you're able to document only 1 year project or 6-month project, you will only get 6-month H1B or 1 year H1B. But you're entitled to all 3 years if your I-140 is approved and you have a project for 3 years. Okay. Star 5 if you have a follow-up question. Star 5. Okay. ASM. Oh, there is a follow-up question. Okay. Let's see, where is this from? So this question is from New Hampshire. New Hampshire, go ahead, please.
Sir, so I'm talking about the extension with a different employer, employer C.
Right.
Can I use the
Right.
140 of
Yes,
employer
yes,
A?
yes, absolutely. This is clearly the law now.
Okay.
The January 2017 regulations made it the law very, very clearly. You can extend your H1 through any employer once your I-140 is approved. Okay?
Okay, thank you, sir.
You're welcome. And you can continue to do it repeatedly as many times as you like, as long as your dates are not current and your I-140 was either not revoked or stayed unrevoked for 180 days. Once 180 days have gone, then you are safe even if they revoke your I-140. Okay?
All right, sir. Thank you.
You're welcome. Okay. Then ASM OSU says EB1 green card was approved when I applied for US citizenship. My case has been pending now for 4 years. You can sue the government. That's too long. So talk with a local litigator wherever you are. File a lawsuit against the government. Before you do that, you can also try this. Contact your congressman's office, especially if they are a Democratic congressman. Because Republicans typically, I shouldn't say that because not everybody is the same, but I definitely expect more cooperation from a Democratic congressman, senator, or House of Representative member, simply because most immigrants tend to vote that way once you become a citizen. So I think there's a little bit of that. But definitely contact your congressman's office. See if they can help you with this situation. Many times, without having to file a lawsuit and take that expense, a congressman can straighten this out for you. Okay? Good luck. Star 5 if you have a follow-up question. The next one from Shiv 784 is a problem with the gender on an approved H1B. Should that be corrected? I always like to get these things corrected, but I don't think this is going to be a fatal problem either for a visa interview or for a re-entry. If I were you, I would do 2 things because there are 2 points of interruption. One is at the visa stamping level. So what you can do is send an email to the consulate and keep a copy of the response. They do respond. Say, I have this problem. Is it okay if I come for visa stamping? Second point of interruption is when you're coming back after the visa, the Customs and Border Protection can stop you at the airport and say, wait a minute, you are supposed to be a man and you are a woman, or you're supposed to be a woman and you're a man. I don't think that's a big deal, big issue, because obviously this is an error. But I would also call CBP and check out their frequently asked questions. Normally, government recommends that you should correct all these things. not have any discrepancies, but I don't think this is a fatal problem. I can't say I've checked this recently, so I would want you to before you make a decision. Star 5 if you have a follow-up question. Okay, let's get you. Let's see, where are you from? Area code 469. We don't know where that is from. Doesn't matter. Hi, good afternoon. Go ahead, please.
Yeah, just now you discussed about my case about gender.
Right.
Yeah, so if I send a mail to consulate,
Right.
my visa is scheduled next month 17th. Suppose by the time if they could not respond, do I need to postpone my
They
visa schedule and everything?
usually get back with you within a couple of days. I have not seen them delayed beyond that.
Okay.
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 Anything else?
It is not required, right? In my case, or is it suggestible to go for amendment?
Well, here's another question. When the gender was mistakenly inserted on the 129, is that any kind of fault of the lawyers, or is that a fault by the USCIS?
It's fault from employer.
Then you have to file an amendment. They will not. Was the case processed premium or regular?
It's regular. Actually, it's the 2018. This year quota.
I don't think you can.
2019 quota.
Look, Shiv, it doesn't hurt to check with the USCIS if they will correct it without any hassle, but typically they will require you to file an amendment. While the amendment is pending, you can certainly travel, and you can keep a copy of the amendment and show it to the government when you go for the visa stamping. But I hate to send people out without having some roadmap from the consulate on how they are going to treat them. So I think really go ahead and file the amendment. That doesn't hurt you, but check with the consulate whether they're going to give you hassles or not. Okay?
Okay. But unfortunately, my visa interview is the next month, 17th. I don't have that much time to file amendment.
Amendment,
go for
sir,
interview.
amendment can be filed tomorrow if you like, because they can use the same LCA. They don't have to get a new LCA. The LCA doesn't contain your gender.
Yeah, but one thing is my client is also changed from day one onwards. But as
Then
within
you have to
NTAs,
have to do more than this. You have, yeah, that's a more complicated situation. Okay.
Okay.
So yeah, definitely.
So can I communicate?
I think in your case, I would rather have you stay back, because you have to do an amendment for your client also. So you shouldn't travel for a visa stamping. Okay.
But as per my employer, it is within 50 miles, so you should not.
Yeah, I have my doubts about that. I think matter of Simeo was poorly stated. They should have said, and I believe that to be the law, sir. They should have said in the matter of Simeo decision, you are not required to file an amendment if your job, your client, your middle vendor, everybody remains the same. Only geographical location changes within 40-50 miles. But if the job changes, the project changes, the middle vendor changes, the end client changes, I think an amendment should be done. Okay?
Okay. So how quickly can, so if we file amendment for my case, including the client, so can I travel or do I need to wait until adjudication on my case?
You can travel. The problem is getting the visa stamping. If you had a visa stamp already on your passport, traveling was not an issue. You can travel during an amendment.
No,
but if you have to go for visa stamping,
this first time I'm going for it.
Yeah, it becomes very messy. I wouldn't want you to travel. Okay?
Okay. So if you want to communicate,
I have to go on. I've got other questions.
In my
Sir,
case,
I have other questions to respond to. I can give you maybe 10 more seconds, so make it really short.
Okay. If I want to communicate personally to discuss furthermore, to whom do I need to contact?
Just send me an email to help@immigration.com. That's my personal email, help@immigration.com. Put down your questions. We'll set up a consultation for you, okay?
Okay.
Good luck, sir. By the way, I'm not going to do any special voodoo. This is not extraordinarily complicated. The laws are quite clear in my mind. It's only a matter of Simeo thing. You should file an amendment. And, I mean, your lawyers can do it just as well as we can. All right?
Okay, thank you, sir.
I'm not
I'll
discouraging you.
get back to you.
I'm not discouraging you from calling, but I don't want to give you the impression that I have some special magic that we are going to do. Okay.
No, thank you, sir.
You're welcome. In some situations, you need some extraordinary help, whether it's extraordinary competence or attention. Certainly reach out to us. But routine cases, I think that's okay as long as it's done carefully. So another question that we have is, and this comes up too actually quite frequently. I've discussed this before. So somebody is in USA, they are a US citizen. They are getting married to somebody outside USA. What is the quickest that person can come? First of all, do not let them come on a tourist visa. Why? Because if they come on a tourist visa, there's a question asked both at the visa stamping stage as well as at the airport, why are you coming? If they say, oh, I'm coming for sightseeing, that's really not true, is it? Because they're coming to see their boyfriend or their fiance or their fiancée. So I think tourist visa is almost universally a bad idea. If you tell the truth and still get a tourist visa, great, power to you, come on in. Second thing, be very careful when somebody has entered on a tourist visa and you apply for a green card for them. Government can take the position that this was fraud because this person had a preconceived intention to apply for a green card. And the use of tourist visa or obtaining the tourist visa, both are inappropriate. So be careful. Now, I did see this should be researched. Please get yourself a local lawyer wherever you are. In some cases, I don't particularly care where the lawyer is. Like, for example, our own practice, business and employment law, we have clients in all 50 states, every major city in this country. You don't really need to be local, but in some things, it helps to have a local lawyer. In this case, though, don't necessarily need a local lawyer, but if somebody you can walk up to and just get good advice, why not? Okay. Family-based cases, normally you don't even need a lawyer, but some people prefer because there are some complications or they don't care for the paperwork, which is quite substantial. So I think this should be researched. I read in one of the, you can actually go online and look at that. Just do a Google search for, let me just run the search. Let me see if it comes up. Yes, what you do is do a search for EFAM, E as in electronic, F as in foreign, A as in affairs, M as in manual. EFAM State Department. When you do that search, you come up with the Foreign Affairs Manual, which is the standard operating procedures of the State Department for granting visas. Go to, I want to say, if I remember correctly, I think 42 FAM, oh no, 9 FAM. Chapter 9 of Foreign Affairs Manual is all about visas. Under 9 FAM, look for tourist or visitor visas and see what activities are permitted on a tourist visa. As I recall, government has said that it's okay to get married while you are visiting, but it's not okay to try to convert to a green card. Don't consider that to be a green light. However, I still have a problem with this. Why? Because if she lands at the airport and they ask her, why are you coming in? And she says, oh, I'm here to see the Grand Canyon, but she's here to get married. I think that's fraud too. So it's a complicated situation. I prefer that you get a one-on-one with a good lawyer. Make sure you discuss all the possibilities. Okay. *5, if there's anything I can answer right now, *5. Press *5 on your phone. Okay. Yeah. And K1 visa is certainly a very good option for somebody who's not married yet. But if you're married, then K3 visa. But they take months. It's not going to happen overnight. Expect anywhere from 6 months to a year and a half for her to come back to the United States. Okay. Now, I have a very odd question from RK, which is very, very strange. So the thing is, they were on L1A, international manager, got laid off, got a notice of revocation of 485. But if you already got your green card approval, I don't see how the government can revoke your green card. I think you should be able to keep your green card. So personally, I think, look, here's what I believe I have somebody raising their hand. Area code 713, which is Texas. Okay, let me just take this first. Texas, did you have a question?
Yeah, good afternoon, Mr. Khanna. This is RK. You are just reading my question.
Okay, yep. You can please call me Rajiv. Nobody calls me Mr. Khanna. Okay, RK.
That's okay. That's fine. That's okay.
Yeah. So I don't see how they can take away a green card. I really don't. If the 485 was approved, there is no way they should be allowed to take away a green card. That is something you should fight. No question in my mind about that.
Yeah, because after 480 was approved, I went to the interview. At the interview, it was approved. They stamped the 551 on my passport, and I also got my physical green card in the mail.
Oh, they can't revoke this.
And 2 weeks.
Oh, they can't revoke this. No question in my mind about that.
Because they sent a notice. Saying that we are revocating a 485.
And not only
and
that,
my
employers. Sir, this is incorrect procedure under their own standard operating procedures. If they want to revoke an approved 485, they must send you a notice of intent to revoke, give you a certain number of days, 10 or 30, to respond to it before they proceed with the revocation. I don't think your case is revocable. I don't see how it is revocable.
Yeah, this is Trump administration, so we can expect. Even my employer's attorney said on the day I was getting terminated, your green card is safe.
Yeah,
they cannot cancel your green card.
Hang on a second. I don't give a damn about what Trump administration thinks they can do. They cannot get away with nonsense like this. So listen, you should definitely file a motion to reopen, reconsider. Okay. But if you don't want to get into all that, see, depending upon where you are located, if you're in Texas, right?
Yeah, Houston, Texas.
Okay, so get yourself a local lawyer and just file a lawsuit against the government. A writ of mandamus would be very appropriate in this circumstance. They can definitely not revoke a green card like this. I don't see how. So go for it. Sue the government.
Yeah, what I'm doing is, I'm just taking a double strategy. I'm already filing for a motion to reopen. At the same time, my local congressman is a Democrat congressman, just like you said. Democrat congressmen are more this thing. So I'm putting all the papers together to put a return request to my local congressman to see whether he can help in making sure that my green card is revoked.
Yeah, I think that's a very good way to go as well. But then if all else fails, that's why the good Lord made courts. You go to court over it, ask the court to stay the decision of the government revoking the green card, so you're not incurring unlawful presence, and you can still continue working because you have a green card. So definitely take it to court. You'll win this case.
Yeah, because I was terminated 3 weeks after I got the green card, so I'm not with that employer anymore.
That doesn't matter. You'll be fine.
Yeah, and my employer is also willing to give a letter. In fact, I'm just communicating with them. They are willing to give a letter as to when the decision was taken to terminate me. So it was after I got my green card. So I'm trying to put all the documentation together.
That's very good. That's a good move. I can almost guarantee you will get your green card back. Okay?
Thank you so much. I only wanted to make sure I'm not getting out of status as of this moment.
No,
because right now I'm just doing consulting.
You are out of status and you are unlawfully present, but it's a mistake.
Okay.
Okay. So if somebody...
So okay. Let me see. I'll keep you informed. Thank you. Thank you, Raju. Appreciate it.
You'll be fine. You'll be fine. I would be surprised if this becomes an issue. You know what?
Thank you.
Do you have a local lawyer in Houston?
Yes, I think I should be contacting Mr. George or Willie, who is a local lawyer.
Okay. Tell them to walk in, take an InfoPass appointment. Don't take you with them. I don't want you to be placed in deportation. Just tell your lawyer to go to the local USCIS office and talk with somebody through an InfoPass appointment with them. I think this is something that looks to me like an error more than anything else. Okay?
Yeah, because he said he hasn't never seen a case like this.
It just can't be done. It can't. It's against the standard operating procedures. It's reversible on that ground alone. Okay.
Okay.
Good luck, sir.
Thank you for your time.
Oh, you're welcome.
Thank you.
Okay, so I've got 6 minutes. Let's see how many questions I can answer. *5 if you have a question. *5. I'm going to go with people who logged in first. So in the order that you logged in. I have 4 questions. I'm pretty sure 5, 6. Okay, 9 questions. There's no way I can get to 9 people. I'm going to start with somebody from California who had called in first. So California, go ahead, please. California. Area code 408. Go ahead, please.
Hi. Yes, Raju, can you hear me?
Sir, I can't hear you.
Hello.
Yeah, go ahead.
Yeah, so my question is that I'm working on H1B, and if I change an employer after a H1B petition is filed and the receipt is received, what are the risks of that?
Well,
Like,
definitely, if you change employers while your transfer is pending, if the transfer is denied, you could have a problem unless the old employer has not yet revoked your H1. Under the new regulations, even if you have changed employers and then the transfer is denied, if the old job is open, you can go back and take it. Okay?
Oh, okay. Okay. So I can,
So,
take the old job,
yes,
the old employer,
yes,
the H1.
yes.
Okay.
All right.
Fine.
Good luck.
All right. Would you have 30 seconds more for one more question?
I'll give you 30 seconds. Go ahead, please, sir.
So my I-140 is approved from a previous employer. I'm not working for them.
Okay.
If they're willing to hire me in future, can they file for a 485?
The answer is yes. The answer is yes. We do it all the time. But I have a bunch of frequently asked questions on exactly this situation. Listen to them. You should be better prepared. And but short answer to your question, can they file? Yes, they can. Okay.
Okay. Great. Thank you so much.
You're welcome. You're welcome. Good luck. Okay, let me see if I can get somebody else also. So we finished California. We'll put that down. Now we come to another one from California. But I thought this was the same person. Huh. Or maybe it's a company. Let's try again. California, go ahead, please. California. Area code 510. Go ahead. I think it's a company. 2 people calling from the same company. Hello.
Hi, Raju.
Yes, ma'am.
Hello.
Yes, ma'am. I can hear you. Go ahead, please.
Thank you. Thank you for your time, Raju. So I appreciate it. So this is not regarding green card. Right now, me and my husband, we are in the process of applying for citizenship.
Okay.
So there is a section where we have to provide all the information regarding any offenses.
Okay.
So we have, both of us have some traffic violations, but it was 3 years before. So when we requested DMV for our record, it was very clean for the past 3 years, but we do have some violations before 3 years,
Okay,
and we don't have any kind.
Let me interrupt you for just one second. There are 2 separate issues here, and let me see if I can help you with them. First issue is,
Okay.
You said violations. Are any of these criminal violations? Were you ever prosecuted for it?
No.
Okay. Are these moving violations or parking tickets?
Moving violations.
Are these any of these moving violations that are considered to be reckless? Normally, reckless goes under a criminal misdemeanor. If they were just speeding, regular speeding, right?
Regular speeding, and I do have an accident. It was 3-car accident, but it was minor car accident.
Okay, but you did not get any kind of criminal prosecution. That is the important thing.
No.
Now comes the second
I
part.
didn't.
So we've discussed one part. I don't think you're going to have any problem. Now let's talk about what we are able to prove and what we are not able to prove. Now, because DMV is not keeping records beyond 3 years, what you should do is, you should write a letter to the USCIS, which should go with your N400 package, that explains, look, to the best of our memory, we have these 4 violations, but there's no history of it because it is more than 3 years ago.
Oh, okay.
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 And I don't think you're going to have any issue, but I would feel a lot more comfortable if you have that letter reviewed by a lawyer. I just want to make sure you don't say something which creates a problem for you, which doesn't really exist. Okay.
So can you repeat the last sentence?
I just want you to have the
Raju?
letter, the explanatory letter about your violations reviewed by a lawyer. I don't usually recommend people get a lawyer for naturalization, but this letter should be reviewed by a lawyer. Okay?
Oh, reviewed by lawyer.
Yep.
Okay, sounds good. Thank you so much.
You're welcome. Good luck.
Raju.
I don't see
Appreciate
this
your
as an
time.
issue at all. You'll be fine. Okay.
Okay, thank you.
Bye. Okay, I'm still trying to zip through. Oh, good. People, oh no, there are still, some people hung up, but 2 people are still here. Okay, guys, just because you've been so patient, let's make sure we get the 2 of you. I have a call scheduled, but they can wait. Okay, let's see. So make it quick. This one is from my neighborhood, Virginia. Go ahead, Virginia. I can hear you.
Yeah, hello, sir. Thank you very much. Okay,
Of
so I
course.
just have a question. It's like, my mom's green card is expiring, say, July 24th,
Okay.
and she wants to go to India in January
Okay.
and return back in mid-June.
Okay.
Will she be allowed to enter in the U.S. because,
Okay.
and then apply for the re-extension?
Sir, I don't remember the exact details, but
Okay.
I think there are a couple of options, and I want you to look into them. Just don't take my word for it because I haven't looked at this issue. Remember that when you have filed, first of all, I think you can file for an extension 6 months ahead of time. Okay.
But
So-
so she cannot do it because right now it will be in January.
In January, and when does she want to come back to USA?
June, mid-June.
And when does her green card expire?
In July 24th.
Oh, I think she'll be fine entering. I don't see any problem at all. When she comes back, she can apply for it. No worries.
Okay, perfect. Thank you very much.
Good luck. Okay, last question of the day, folks, and then we are all done. Let's see. This one is, oh, I think they hung up. All right. Well, very good, guys. This is actually exactly right time for me. It's 1:31. It's great to talk with all of you, and I really appreciate the opportunity to be able to interact with you. We'll talk again in 2 weeks. Good luck, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.